So, good morning again, and we're going to be looking this morning at the new Revenue and Customs joint liability notices, which set up personal liability for corporate taxes for directors, and which arise under Schedule 13 of the Finance Act. So, the way I'm looking at this is I'm treating it as being three separate flavours of joint liability notices for different classes of directors who are at risk. And the three flavours, as I'm describing them, and as far as I know, nobody else, are the slippery ones. And those are the directors whose companies have been involved in tax avoidance schemes or tax evasion. Second category, second flavour, are the serial offenders, and these are the people with a string of failed Phoenix companies behind them, in cases where HMRC have been left on at least one occasion as the major creditor. And the third flavour are the ones I'm describing as the evil geniuses, and these are, I think, likely to be companies whose business has been tax advisory work, and where they've actually overstepped the mark in what they were doing, and those incorporated practices now have got HMRC penalties threatened or imposed against them. Now, directors, and it's not just directors, it goes rather wider than that, but directors of companies in any of those three categories could be served with a formal notice, a joint liability notice, and that will make them personally liable jointly and severally with the company for the debt to Revenue and Customs. And in the case of the repeat offender flavour of joint liability notice, the notice is not only an obligation to pay historic tax arrears, but it's also effectively a 5-year personal guarantee by the director on the tax liabilities of their company for the next 5 years. And the notice itself is issued by Revenue and Customs by administrative decision. It itself establishes the liability. There's no application to court. There's no third party to review it before it happens. As soon as the notice is sent, the director has that liability. They have got some limited rights of appeal against it, but they are going to be on the back foot. It's for them to prove innocence, if you like, at that stage. A little bit of the law behind it. Say it's Section 100 of the Finance Act 2020, which brings in Schedule 13 of the Finance Act, which is where you will find the detail. And it is effective as from the 22nd of July this year. Now, it's a phasing in of the new legislation, in that the principle behind it is that directors should not be made personally liable for things that they did or things that their company failed to do before the 22nd of July 2020. So as time goes by, and as Revenue and Customs have a longer period of time that they can look at as the basis for issuing these, I think we will probably see rather more of them. And in terms of the key points about the personal liability for tax, as I say, it is the joint liability notice itself that actually establishes that personal liability that the individual has for their company's corporate taxes. The director is jointly and severally liable with the company, so they then have an incentive on making sure that the company does pay. But if the company has ceased to exist, if it's been dissolved, then the director will be liable on their own. And as I said earlier, the joint liability notice is the document that establishes the debt. That's it. There's no legal proceedings to follow it. It's not a notice of intention. It is a done deal. There are rights of review and appeal, but they are fairly limited. I'll talk about those at the end of this presentation. And the issue is that it's really more for the director then to prove their innocence. They've got to set aside the notice rather than the revenue having to prove the facts behind it. I'm going to be talking about these joint liability notices as coming in three different flavours. The first flavour is what I'm calling the slippery ones, and these are the ones that are addressed to people who have been involved in tax avoidance and tax evasion, and the details of those notices is in paragraph 2 of Schedule 13. The second flavour are the repeat offenders, the people who have got 2 or more Phoenix companies behind them, and who are known to Revenue and Customs for that reason. And the third category are the ones I'm calling the evil geniuses, and these are businesses that have been involved in avoidance and evasion schemes, and have sailed too close to the wind, and as a result have themselves been penalised for doing so. Looking at each of those in turns, I'll start with the slippery ones. There are 5 conditions that Revenue and Customs needs to have to trigger their right to issue a joint liability notice to somebody as a slippery one. The first one is that the company has been involved in tax avoidance or tax evasion. I'll say a bit more about that in a moment. And the second one is that the company is either insolvent or is becoming insolvent. Now, the definition of tax avoidance and tax evasion here, there's a list of specific provisions which mostly arise under the general anti-avoidance provision. They're in paragraph 6 of Schedule 13, and the insolvent company has to have been involved in one or more of those, or has to have been involved in tax evasive conduct. And the implication behind the definition of tax evasive conduct is that the company will have been deliberately misleading Revenue and Customs about what they've been up to. And the definition of insolvent for these purposes, it's the usual list of statutory procedures. It doesn't include receiverships other than administrative receiverships. It includes MVLs if they fail, and it also includes companies that have been struck off and dissolved without first going through a formal insolvency procedure, which is an interesting addition to that particular list, and it includes overseas equivalents as well. So back to the 5 conditions for a slippery one joint liability notice. I've already mentioned that there's got to have been some tax monkey business by the company, and the company has to be insolvent. The third one is about the connection that the director, the individual, has to the company. And there are 2 options here. Either that they were at the time a director or a participator, and in that capacity they were either responsible for the monkey business or they benefited personally from it, or they were at the time a director or involved even indirectly in the management of the company, and they were themselves personally involved with the tax monkey business. That second limb about being involved even indirectly is incredibly wide, and I'd be slightly concerned that that might even catch professional advisors in some cases. So let's have a look a bit more at what's meant by being a participator or a director or involved with the company. Director, the definition is as you'd expect. It includes shadow directors, and it includes people who have acted as a director without being appointed formally to that role. Definition of a participator is incredibly wide. It includes all shareholders, no matter how tiny their shareholding is, and it includes all loan creditors and anybody with any interest in the company's capital or income. So that's an incredibly broad definition to be a participator, and a participator can, if they've been involved in the tax avoidance or evasion, they can find themselves personally liable jointly and separately with the company for it. So those are the first 3 conditions to a slippery one joint liability notice: some sort of tax monkey business, a bust company, and a personal connection between the individual concerned and the company through its management or ownership. The last 2 conditions are that the there will be a tax bill raised by Revenue and Customs as a result of that avoidance or evasion, and that Revenue and Customs think it's likely that some of the bill won't be paid. Now, that last condition seems to be a racing certainty in cases where the company is already insolvent or is going to become insolvent. That's then a quick run through of what the contents of the joint liability notice will have in it. I won't say any more about that. The slides will be available after this. We'll email them out to you. So that's looking at the first of the three flavours, the joint liability notices for slippery ones. Let's have a look at the second, the joint liability notices for repeat offenders. These are possibly the ones that we're most likely to come up with in insolvency practice, the people with a history of Phoenix companies behind them. So there are four conditions here that could trigger a joint liability notice. The first one is that the individual concerned has to have a history behind them of two or more insolvent companies. There also has to be a Phoenix in here somewhere. So the business in the third company, the new company, has to be a Phoenix that was previously operated by at least two of the previous insolvent companies. And there has to be a personal connection between the individual concerned and the company within the last 5 years. And that's a personal connection between them and the new company. There will also be a personal connection between them and the bus companies, which I'll talk about in a moment. And there is then a minimum threshold for the unpaid tax. At least one of the bus companies must owe a certain minimum amount to the Revenue and Customs for them to be entitled to serve a joint liability notice on somebody involved in the management of the new company. So let's look at the detail of that in a bit more. There are these, in addition to these four conditions, there is also a precondition, which is a limitation period. And essentially this says that once Revenue and Customs have enough information to issue a joint liability notice, they must either issue the notice within 2 years or they lose the right to do so. Now that's a very, very vague limitation period, and it's going to be very, very difficult to prove that Revenue and Customs are outside the 2-year limit at any one time. But I suppose once a director has cooperated to the fullest extent, disclosed absolutely everything to HMRC, then once they've made that complete and full disclosure, then they should be safe once 2 years has gone by beyond that in terms of getting a joint liability notice. In terms of looking at the conditions that must apply to the two bus companies, there has to be a personal connection between the individual concerned and both of the bus companies. They both have to have been bussed within the last 5 years. So essentially, the points come off your license after 5 years. And for both of the two bus companies, one of the following three must also apply in terms of Revenue and Customs defaults. The defaults can be either unpaid tax, or they can be arrears of returns or other paperwork, or just failure to cooperate with HMRC. There has to be this personal connection between the individual and the two bus companies, and that is, as it was with the slippery ones, that they have to have been a director or a participator. And the third way of them being connected is if they were concerned even in an indirect way with the management of the company. That is again incredibly broad and could certainly catch people who have put up a member of their family as a patsy to run the company for them. And there also has to be this unpaid tax threshold. So the total tax owed by the 2 or more insolvent companies has to be either or both of them more than £10,000 in total, and revenue has to be the biggest single creditor. They have to be owed more than half of the total tax owed to unsecured creditors. So again, if you have a director who's looking to manage an insolvency to protect themselves for the future from something like this, they need to make sure that that the other unsecured creditors are more than the amount that they owe to Revenue and Customs. And again, I won't go through the detail of what the contents of the joint liability notice will be, except middle of that slide, you'll see item 2, the second item there, is that the director, the individual concerned, is not just responsible for the unpaid tax of the phoenixes, the insolvent companies, but there is a 5-year personal guarantee on the new company's tax going into the future. So that is something that I think would be a deterrent to them in having a third phoenix for this particular business as well. So those were the first 2 of the flavours of joint liability notices, the slippery ones where there's been tax monkey business by the insolvent company in the past, the repeat offenders, those with a history of phoenixes that have left Revenue and Customs high and dry. We'll now look at the third flavour, the evil geniuses, and these are companies which have been penalised by Revenue and Customs for their involvement with avoidance or evasion by others. So this is essentially companies involved in tax advisory work, I think. And there are 4 conditions here for Revenue and Customs to tick off before they can issue a joint liability notice under this flavour. The first one is that the company must have been hit by a penalty from a particular shopping list, or they must have started proceedings against the company for a penalty on that list. The second one is that the company has got to be insolvent or going insolvent. And the third one is that when the company triggered the penalty, the individual was at that time either a director or a participator, shareholder or other involvement with the ownership or funding of the company. And the fourth one is that Revenue and Customs must think that there is a risk that some of the penalty won't be paid, which again I'd say that's going to be very difficult to argue against in cases where the company is bust. The list of penalties are essentially, well, it's in paragraph 5 of Schedule 6, and it's about non-disclosure of schemes. It's essentially about failure to cooperate with Revenue and Customs and promoting schemes that Revenue and Customs have regarded at the time or subsequently as being beyond the pale. Again, a reminder that the definition here of director and participator is consistent throughout all of the flavours of the joint liability notices. And again, that's the list of what the contents of the joint liability notice are. And I won't go through that in any detail, but it will be on the handouts that will be sent to you later. I'll say a bit about reviews and appeals. Somebody who receives a joint liability notice and wants to challenge it, they've got 2 routes. They can either appeal directly to a revenue tribunal, or they can start with the administrative procedure of review by Revenue and Customs, which would then give them the right to appeal to a tribunal if their review is unsuccessful. It's a fairly limited right of review and appeal that they've got. They can dispute the basis for issuing the notice. So those detailed list of contents, they can check through those and see whether they think that it is fair to consider them to have triggered the ones that are being referred to in the notice by Revenue and Customs. What they can't do, they can't challenge the liability or the penalty that Revenue is claiming from the company, whether they've issued proceedings or whether they've already got the penalty in place. Now, if the company is actually fighting that liability through the tribunal or whatever means, then the director does have the right to join as an additional party. And if the company then ceases to pursue the appeal, the director can continue with it. Now, the significance for us as insolvency professionals is that you may be asked as liquidator to appeal an unsecured liability or preferential liability that Revenue and Customs has against the company. It's not something you would normally do, but it might be something that you would consider doing to help the director to defend and protect their own position. You would probably want a fairly solid indemnity against them for starting the appeal, and I think you would probably want the company to discontinue the appeal as soon as it's issued it, so that the director can themselves join as a party and can then effectively run it entirely themselves. Other implications for you as an insolvency practitioner, and we've got a one-page crib sheet that we will email to you in the course of this week as something that you might find useful to take into meetings with directors from the outset. You're not going to want to be involved in advising directors about this themselves, so I guess you're more interested in looking for something which is essentially a tripwire, a warning bell that will tell you when you need to be steering directors towards independent advice on their own personal circumstances. And I think it's going to be quite important to watch out for the 3 at-risk categories and to be aware of the 3 flavours of joint liability notices, so that you hear those alarm bells ringing with perhaps a different warning tone for a director who is one of the slippery ones, one of the repeat offenders, or one who is an evil genius as they sit down in front of your desk. And you might find that in some cases directors might want to work a little harder at tidying up the company before they start the liquidation process. And you may find that they're more enthusiastic than they have been in the past in making sure that unpaid tax is below the trigger threshold, certainly in the case of Phoenix companies, repeat offenders. You may be asked to think about the implications of being asked to start or continue an appeal. The appeal may start before the company goes into liquidation, or you might find yourself as liquidator being asked to carry on with it then. And you'll also have to remember as well that HMRC may now be a preferential creditor for some of the liabilities concerned in this, and that might have implications as well. It might actually be a get-out-of-jail card for some of the directors if the Revenue's preferential status does actually allow for a significant part of the liability to be paid. So that is it. It is just about 11 o'clock, I think. If anybody has any questions, then please do drop me a line in the chat box. I haven't got any yet, which is quite nice because I don't regard myself as being any sort of a tax specialist. So I'm not sure that I would necessarily be able to deal with much of the detail of this. But as I say, we have got a briefing note that we will be emailing to all of you a bit later, which just is a short crib sheet that you may find useful when advising directors.